Hello and welcome to the 21st episode of Business Litigation TV, the internet's most passionate show about business litigation. I'm your host, Jesse David Eisenberg. I'm a business litigation attorney here in New York City. And if you have any questions after watching this, you can always email me at Jesse, Jesse, at jdelaw.nyc. Today I want to talk about a frequently asked question I get. I always get, once I sign up a client, what happens if they don't answer the complaint? So here's kind of the process of what happens once you sign up with me. First, I file the summons complaint with the court. Then I send out the summons and complaint with my process server. Now, because this is business litigation, if you are suing another business, then what happens is I always have the process server serve through the Secretary of State. That way, once you serve with the Secretary of State, it's automatic service accepted. So a business can't come back and say, well, you didn't properly serve me. There's no argument to that when you use the Secretary of State. So then with the Secretary of State, they send out the summons complaint for you. But anyway, once you've served the defendant, they get 20 to 30 days, depending on how you served, to answer the complaint. Now, once those 20 to 30 days have passed, I always, because it's according to law, I send out by mail another summons complaint to either the business or the person at their address. I give that a little bit of time. If I don't get an answer at that point, the next step is I make a motion for a default judgment. Now, when I make the motion for default judgment, that's when a lot of people show up. They're like, hey, wait a minute, I'm here. Okay, when that happens, I vacate my motion. We continue the case as it's supposed to go. Something to remember, though, when you serve through the Secretary of State, I've seen it where the Secretary of State didn't actually get the summons complaint to the business for like 45 days. So in that case, you always are going to vacate or take out your motion or vacate at that point because you understand they didn't actually have the complaint. After you make the motion, one of three things happens. Like I said, they show up. I'm sorry, let me back up. Once the motion is granted for default judgment, one of three things always happens. The defendant shows up. When they show up, you have to make a choice. Do you make them make the motion to vacate the default judgment, or do you just vacate it and continue the case? And I'll explain a little more at the end why you may just vacate it yourself. Not worry about them making a motion. But sometimes, you got to realize if they didn't take like a year and a half to enter the case, the judge is always going to allow them back in. It's kind of the difference between what the law is written and how it's practiced by the judges. So that's option one. They show up. Option two, they don't show up. Now, if you're suing for an exact amount, let's say $50,000, you paid someone $50,000 to paint, you handed them the money, they never painted. So you know that they owe you $50,000. The judge will then, in your default judgment order, will say, okay, judgment for $50,000. If it's an amount that can't just be determined easily like that, you have what's called an inquest. It's kind of like a mini trial. You still have to present evidence that, hey, the defendants were the ones who did something wrong, and then this is the harm it caused. They owe me $22,416.14, something like that. And then you get a judgment. So those are the next two options. You have the exact sum, or you have to prove it at inquest. Either way, at the end of the day, you have to chase the defendant's assets to try and collect. So that's options 1, 2, and 3. Now, like I said, in my opinion, it's better if you just let them in the case, usually because you have a chance to actually get somewhere. Okay, you have a chance of seeing your money. You may have to settle for $45,000 instead of $50,000, but then at the end of the day, they're writing that check, and you get the money instead of spending a year, 5 years, 10 years trying to chase after the $45,000. That's why you want someone in there. If you have to chase assets, it takes a long time. Unless we're talking like it's Con Ed or something who you know where they are, you know how to get the money, something like that. You know where their bank accounts are. So that's why, in my opinion, you actually want the case to proceed how it's supposed to proceed. That's why it's worth the extra month or whatever for them to enter the case. Otherwise, like I said, you're chasing assets, and it actually is going to cost you more time and more money in lawyers' fees a lot of times too. So I hope that answers your frequently asked questions. Again, want to discuss something with me, something was unclear, please feel free to email me at Jesse, Jesse, at jdelaw.nyc. Until next time, take care.